Okay.
Good morning and welcome to today's session of the Kansas Court of Appeals, meeting remotely on Zoom. We have our last case here on the docket today. My name is Catherine Gardner. I will serve as the presiding judge. And on your screen on your left is Judge Michael Boozer, who's been on the Court of Appeals since 2005. And on your right is Judge Bruns, who's been on the Court of Appeals since 2011. So I will call the case of 122553, Michael D. Riley, appellant versus the Kansas State Board of Healing Arts. Counsel, will you state your appearances, please?
May it please the court, for the appellant, Michael Riley, is Mark Stafford of the Forbes Law Group.
Thank you.
May it please the court, Courtney Sisman, Deputy General Counsel, and Tucker Poling, Acting Executive Director and General Counsel, appear on behalf of the appellee.
And which one of you will be arguing?
I will.
Okay, you're not on the brief, I don't think.
I am. My name changed. I was formerly Courtney Manley. So,
is your bar number then on the brief as well?
It is.
Okay, thank you. Very good. Well, and Mr. Stafford, would you like any time for a rebuttal?
I would like to reserve 3 minutes, please.
3, and this is set for 20 minutes, correct?
Correct.
Okay, you may proceed, Mr. Stafford.
Thank you. And in preparing these, I tried to build in sufficient time for questions by the court. This is an appeal of agency action. It's an appeal of an order finding that Michael Riley had used fraudulent or false advertising. Dr. Riley is a doctor of chiropractic. He's licensed by the Kansas Board of Healing Arts. So, for purposes of this Healing Arts Act matter, we're looking at whether his advertisements were false or fraudulent. False advertisement is defined by statute. That occurs at KS subsection C. The statute says advertisement must be false, misleading, or deceptive in a material respect. First of all, we do not concede that the advertisement is fraudulent or false in any respect. But we do want to point out, as we did in the brief, that the board found, or concluded rather, that the statute required they be false in any respect, or rather in some respect. I apologize. In some respect is not the same as material respect.
Now, let me ask you about that, Mr. Stafford. When I read that in its context, it seems as though perhaps what the board was saying is that it can be material, it can be an omission, or it can be a commission in some respect, because it goes ahead and talks about that in the next sentence. So it's not, to me, it's not necessarily that the board is saying if it's false at all in some insignificant way, that's enough. It seems to me the board might just be saying if it's materially an omission or a material affirmative statement, either one of those can be enough.
I understand what you're saying. My reading of it is that they did not require anything to be material to a person's decision-making process. And that's why I point out the difference here. Something could be false or misleading or deceptive in such an immaterial manner that no reasonable person would have any reaction to it. We don't know what the board's thinking was here necessarily. That's the reason for the argument. I believe that the board should find or not find that the statement that causes them heartburn would would make a difference in a person's reading of the advertisement. So, in this case, we ask, what did the board have before it when it reached its conclusions regarding the advertisement? What kind of evidence? They had the printed advertisements. They had an investigator's narrative statement. They had Dr. Riley's remarks, testimony at the hearing, and those appear in the agency record in the transcript. And they had past settlement agreements between the board and Dr. Riley. What did the board not have before it? There's no testimony of any witness other than Dr. Riley. It was pointed out in the transcript that the staff chose not to disclose the complaint or the complainant to Dr. Riley. It appears from the agency record that neither did the board have access to that information. So all we have are the ads themselves and an investigator's narrative statement written and Dr. Riley's statement testimony.
Mr. Stafford, let me, before you go on, you mentioned, and I don't know if it was called a consent agreement or whatever he had signed previously. What role does that play, and did he make some admissions against interest that are applicable here?
So, yes, that's one of the issues here on the appeals. What role do those have? I believe that there's no question that they might mitigate or they may aggravate a violation. The board used those, though, to provide context for these advertisements. And I believe the finding is pretty clear, the legal conclusion is pretty clear that based upon those, they found the violation. Based upon those other orders, they found the violation. And our belief is that while those prior disciplinary agreements might aggravate a situation, they do not turn a non-violation into a violation.
Did he, and I'm just wondering, would you agree that in the consent agreement or whatever the document was called, that he admitted that he was aware that it was a violation to solicit a treatment process or procedure that would result in the patient being pain-free? I mean, is that something that he admitted to in the consent agreement?
I think there was a prior consent agreement that touched on that issue. I believe that that is a misstatement of the law. And he pointed out in his statement, and by the way, when he appeared before the board in this proceeding, he was pro se. He pointed out his disagreement with that concept. And this has to do with the concept of it being a guarantee or an agreement, promise rather, that the patient would become pain-free. He said he's not guaranteeing results. If you take the example of a doctor who does lap band surgeries, are you going to criticize the doctor for saying that you will lose weight? And he was trying to articulate that he was not trying to guarantee anything. He was just trying to tell people about a treatment regimen that might be right for some people, and it might alleviate the pain that some people experience. I'm not sure that, does that address question?
Well, that certainly addresses the question that I'm asking, yes.
Okay, thank you. The without the evidence, without any evidence of somebody being misled, without evidence that somebody was actually complaining that this was a material issue in their decision to go see Dr. Riley, we almost have to conclude that the board has a per se prohibition on using the term pain-free. And that leads to problems. If you say that there is an absolute prohibition against the phrase pain-free, then he would not even be able to say, I doubt this will make you pain-free, but it might make you feel better. So an absolute prohibition against that phrase would not be appropriate.
Counsel, is it your position that the board needed to have patients come in and testify that they had this core procedure and in fact they still have pain? Therefore, the advertisement was materially false.
I think that would be one approach to proving the case. But in this case, they didn't even attack the quality of the treatment regimen. They didn't say that this treatment regimen would not work or might work on some people, but not everybody. There was no question regarding that. So we have to presume that the treatment regimen itself was valid.
Well, but in the district court's ruling on this matter, I'm looking at volume 1, page 46 of the record. The district court said the Healing Arts Act prohibits advertising to guarantee any professional service or to perform any operation painlessly. Now, that seems to me to pretty much directly go at the issue of whether or not a professional service is going to make you pain-free or whether the treatment that I'm going to give you is going to be pain-free. And that seems, based on just the plain language of these advertisements, that they were saying that you're going to be pain-free if we select you for the core procedure and you get it.
Well, I respectfully disagree with the reading on at least part of that. The prohibition against advertising a procedure to be pain-free was actually discussed on the record. Dr. Templeton, in her questioning the board counsel, said the statute doesn't prohibit advertising the patient will be pain-free. It prohibits that the procedure itself will be pain-free. As far as the guarantee, if there was a blanket guarantee that this procedure works for everyone, it would probably be a problem. But in this case, I think it was pretty clear that this procedure is not going to help everyone. It's going to help people. Go ahead.
Show me in the advertisement where that's made clear, please.
Yes, and I talked about those at page 16 of my brief, I believe. I'm looking at Exhibit 3, for example, and that's at the agency record on page 24. And it has the headline on top, do you suffer from neuropathy? And there's a statement, will this treatment work for you? The best way to find out if you're a candidate is to come in and experience it.
But if you're a candidate for the treatment, then the advertisement says that you're going to have a pain-free life if you're accepted into the treatment, correct?
I don't know that I see that as being a guarantee, but we might just have to disagree on that. I think the condition that is in there certainly detracts from it being a guarantee. If a person is a candidate, if they do have pressure on the nerve root and they relieve that pressure, then you can expect a certain result, much like the lap band surgeon who wraps a band around your stomach. You can expect that person not to eat as much and thus will lose weight.
But the lap band surgery does not guarantee that you will lose weight permanently.
As long as the lap band is on, that's the example that he used and why he did not feel like it was guaranteed any more than other advertisements.
I guess the contrast that I see between whether or not it's a promise of pain-free results or not was in the last two sentences of your brief, where you say that the advertisements at issue do not offer or necessarily imply false hope to patients. They merely offer a treatment that might help them reduce their pain. If the doctor had said what you said in the last sentence there, we wouldn't be here. And I see a big difference between what you're saying here and what the advertisement, the plain language of the advertisement said.
I, again, just have to disagree that that is what the advertisements read, or how they read, or what they imply.
All right.
I think if a doctor advertises, come on in, get this treatment, it's not going to work, it's probably not going to be a very effective advertisement. But
Mr. Stafford, let's talk a little bit about standard of review. As
okay.
appellate courts, we just love to talk about standard of review. Certainly interpreting the statute or even a regulation would fall within the purview of this court.
Yes.
But actually applying the statute to a specific set of facts, is that something that we're supposed to replace our judgment for that of the Board of Healing Arts, or do we yield to the Board of Healing Arts if there's substantial competent evidence to support their decision in applying the statute?
If we are limiting our discussion to this case, there is no evidence other than the advertisement itself. So that is the fact, what the advertisement says.
And is it your position that we can review the plain language of the advertisements just as well as the Board of Healing Arts?
Absolutely. It is a mixed question of law and fact. There's no question about that. And we know the well stated rule that the court's not bound or necessarily even influenced by the agency's interpretation. If the agency findings of fact, just in a general term, the agency findings of fact are such that they would, by application of law, reach a necessary conclusion, that probably is going to limit a court's review. But where the fact is pretty simple, where the fact is a document that you can review as well as the court, and you apply legal rationale, then I think you have the ability to overcome the agency's ultimate conclusion. I think that is certainly a matter of law that you have ultimate authority.
Mr. Stafford, are you in agreement that the doctor's failure to put his name and the fact that he is a doctor of chiropractic on one or more of these advertisements was a violation of the healing arts regulations?
No, Your Honor, I'm not. Um, and that's one of the areas that I wanted to touch on also. If he was advertising his services,
I think we've lost him a little bit there.
You froze a little bit, so you might want to repeat what you were saying.
okay. In this case, the exhibit number 5, I believe, is the one that is in question, where the name and profession are not identified in the advertisement. I just got a message that my internet connection is unstable. I certainly hope I don't lose you.
Well, if we do, we'll wait for you to get back on.
I appreciate that.
Yep.
Exhibit 5 did not advertise his services. Exhibit 5 advertised medical equipment, a knee brace. And that's all it did. It did advertise a person coming in and being treated by the doctor. It was a retail sale of a product by the company, Renuva. And in that regard, I don't believe that it was misleading, was it deceptive, was it false for him to leave out his name and profession. And the board could probably adopt a rule that said, if you advertise, you must, in every circumstance, include your name and profession. But there is no such rule. If he
Mr.
had,
Stafford,
yes,
you're getting into your rebuttal time, which is fine.
okay. One final point was the statement of page 1 of the appellant's brief that the appellant admitted he could see how his advertisements could be interpreted. That's not evidence. That was a narrative statement in a written investigative report. But we don't know if it was a quote, a conclusion, an interpretation. And there's no citation to the record in the brief for what they're referring to. I presume it's here in Exhibit 6, which is at the agency record, page 28 and 29. It's not quote-worthy. Dr. Riley testified at the hearing that he understood how the advertisements might be misinterpreted to make a guarantee of price, but those would be misinterpretations. That's at the transcript, page 8 and 9. I think we've touched on all the issues, and I will yield to counsel.
Thank you, Mr. Stafford. Ms. Sisman, you may proceed.
Thank you, Your Honor. In its order, the district court emphatically stated, a plain reading of the advertisements demand that this court affirm the board. We now ask this court to conclude and do the same. Dr. Riley ran several paid advertisements indicating treatment he was offering would result in a pain-free outcome. And one of those advertisements failed to identify himself or his profession as a chiropractor. The board determined that these advertisements were misleading in violation of the Kansas Healing Arts Act. As this was not Dr. Riley's first violation of the Healing Arts Act, in fact, it was his fourth. And after considering the aggravated and mitigating factors in this case, the board determined that the appropriate sanction was a 90-day suspension, a $7,500 fine, and an ethics exam. Now, Dr. Riley is attempting—
Let me interrupt you. What do you say to his response to the fact that he didn't identify himself as a chiropractor by name on Exhibit 5 by saying that's just the sale of a product and not advertising his services?
So that goes directly to the board's finding that he violated KSA 652836B as further defined by KSA 652837B1, and that he used a false or fraudulent advertisement. So when you look at the definition of a false advertisement under 652837C, It's any advertisement that is false, misleading, or deceptive in a material respect. But at the end, it also says you have to look at the extent to which the advertisement fails to reveal facts, material, in light of such representations made. When you look at Board Exhibit 5, this advertisement, it's not just an advertisement for a knee brace. He's clearly advertising for his treatment of core care and a knee brace. And when a reasonable person looks at this, you can't tell which type of profession of the healing arts it is. So there are physicians and there are also chiropractors that practice the healing arts, and you can't tell. So I want to back up a little bit in terms of the scope of judicial review and remind the court that the board's final order has a presumption of validity on review. And the burden is all on Dr. Riley trying to prove the invalidity. And even if the reviewing court would have weighed the evidence differently or exercised its discretion differently, the Kansas Judicial Review Act prohibits the court from re-weighing evidence or engaging in de novo review. So going back to the substantial evidence in this case, you obviously have to look at in light of the record as a whole, and substantial evidence is evidence that a reasonable person would determine would support a conclusion. So we've touched on Exhibit 5 in the first violation that the board found, but the board also found that Dr. Riley violated KSA 652837 B13, and that he made a false or misleading statement regarding the skill or efficacy or value of the treatment or remedy. So this goes on to really a lot of the other advertisements in this case. So Exhibit 2, which is on Volume 2, page 38 through 40, you'll notice the title, Overland Park Doctor Offers New Treatment for Chronic Pain. And on page 40, it says, remember what it was like before you had these problems, when you were pain-free. You could enjoy everything life has to offer. It can be that way again. We look forward to helping you become pain-free. He then also ran further advertisements, which is Exhibit 3 on Volume 2, page 41, and Exhibit 4 on Volume 2, page 42. These say the same thing so that we can start mapping out your plan to becoming pain-free. And this could be your pain solution, like it has been for so many other patients. Then we talked about Exhibit 5, the Kansas City Star article, but also Exhibit 10 is the Wichita Eagle. And this one says, pain should not be accepted as part of the aging process. Drugs and surgery are not your only options. Quality of life is important, and life should be enjoyed to the fullest, pain-free. Now, Dr. Riley attempts to add context to this now, but that doesn't change the impermissible use of this language. And these advertisements are the substantial evidence supporting the board's violation. Now,
let me just ask you, there's no specific part of the statute here that prohibits using the words pain-free as regarding an outcome. And there is some pain-free language in the statute relating to a surgery or an operation or specific matters a physician could do. But as far as a pain-free outcome, there's no statute that specifically prohibits those words. It's just that the board takes the position, apparently consistently, that use of those words violates the false advertising statute. Is that correct?
Your Honor, there is no blanket prohibition on the use of the terms pain-free. That is correct. What's important is the way that Dr. Riley in this case used the terms pain-free, and it goes towards the B13 violation and towards the efficacy and value of a treatment, in that a patient who undergoes his treatment is going to be pain-free. Now, appellant has touched on the board's prior settlement agreements with Dr. Riley and suggested that they were part of the board's conclusions of law, but the district court correctly said that they were not. They are merely lending itself to the aggravating factors in this case as to why the sanction is higher than that of the prior ones. The board has clearly tried to remediate him in the past, and here we are for the fourth time for largely the same issue. Next, the district court correctly concluded that the board resolved all issues and correctly interpreted and applied the law. The Kansas legislature unambiguously defined the false advertisement. And now appellant attempts to argue that the board did not make a determination that the false advertisement was material, and quibbles with words, and that the board found in some respect that it was material in some way. But that's not the case. Here, the board clearly laid out the whole statute in terms of what a false advertisement is, and the board found that the advertisement was misleading. And the district court concluded that conclusion of materiality is clearly inherent in the substantive conclusion that something is misleading. That is exactly what happened in this case. Also, the board correctly interpreted and applied the law for false advertisement. The district court said it was not an unreasonable interpretation for the board to rule in this way. And the district court specifically noted, even though the advertisement restricts its pain-free promise to those who qualify, it still makes a pain-free promise to qualified candidates. And the other advertisements heavily imply Renuva believes life should be enjoyed pain-free and that its services will provide patients a pain-free alternative. Now, Dr. Riley has provided this novel argument that Kansas law requires a specific person to be actually misled by an advertisement or harmed, but that's incorrect. The district court was correct in stating the Kansas Healing Arts Act does not require a finding of actual harm for there to be grounds for disciplinary action. This is laid out in Pfizer versus Kansas State Board of Healing Arts, 281 Can 268, 2006. And the district court explained, it's clear that the Kansas Healing Arts Act really appears to be more concerned with the means and not the ends. And if you look at the statutory violations in this matter, 2837 B1, B12, B13, they clearly all have an objective standard. This is not a subjective. Kansas law does not require a patient to be harmed or misled, and so appellant's argument on that fails.
Let me ask you about B12, which prohibits conduct likely to deceive or harm the public. When you look at that standard of likeliness, is that more likely than not? Is it a probability? Are there any cases that flush out what that standard is?
It's a probability. Here the case even went further. We actually did find that he did mislead the public. So we met that standard, even if it was a probability. Here it was met. The board found that he was misleading.
Well, the board found that his statements were inherently misleading. They didn't find any person to say, yes, I was misled, correct?
Correct, but that is not required under the law. So. And I do briefly want to touch on appellant's First Amendment argument that is both in our briefs, but this argument is really irrelevant and circular to this matter. Truthful advertising relating to lawful activities is entitled to protections of the First Amendment, but it's clear the United States Supreme Court has said that misleading advertisement is prohibited in its entirety. Nowhere in this final order are you going to find a conclusion that his advertisements were not misleading, yet nonetheless a violation of the Healing Arts Act. We found that the advertisement was misleading, therefore it's not entitled to First Amendment protection.
So if the advertisements are false, they're simply not entitled to First Amendment protection. And if we find his statements were not false or misleading, then we'll simply reverse the board.
Correct, and thus there's no infringement, and thus the circular argument. So I do also want to note that the Kansas courts have addressed this before in Bolton versus Kansas State Board of Healing Arts. And they explain the practice of puffery is well established in a non-professional advertising, but it has no place in advertising of the healing arts professions. The well-being of the people, the public of Kansas, who may be unsophisticated in healthcare matters, is the compelling interest, and the licensor of the healing arts has the right and duty to demand strict adherence. So because the board's findings were supported by substantial evidence, because it correctly interpreted and applied the law, and it resolved all issues requiring determination, there was nothing unreasonable, arbitrary, or capricious in this matter. The appellant has fallen far short of his burden to prove the board's order was invalid. The district court determined that as well. We request that this court affirm the district court's order, affirming the board's final order, and dismissing the petition for judicial review.
Thank you, Ms. Sisman. Mr. Stafford, you have about 2.5 minutes left in your rebuttal.
Okay, thank you. I want to deal with KSA 652837, subsection B13, that the board cited on the second page of its final order. And basically it says that it prohibits making a false or misleading statement regarding skill, or efficacy, or value of treatment. And again, the doctor's personal skill, the effectiveness of the treatment were not part of the hearing. There is zero evidence that he lacks the skill or that his treatments do not have the outcome that one hopes for. I want to go to the prior case and our prior cases that were discussed, those prior consent orders, and how the board's conclusion really was, as the district court said, a discussion of mitigating or aggravating circumstances. And yet the board's final order says, under the facts of this case, including but not limited to the contextual background of licensee's prior board actions referenced in the facts incorporated above and described in Exhibits 8 and 9 to the petition, the board finds that the advertisements were misleading. They were making the misleading conclusion based on those prior board actions. I want to briefly discuss Bolton. First of all, that's in a different setting than we have now. We agree. Puffery is probably not appropriate, even today, years after Bolton. And yet, I drive by and see advertisements. Come see me for the very best depression treatment possible. That's puffery. What Dr. Riley gave was not puffery about his abilities or about the abilities of the treatment. It's not harmless exaggeration. It's something that he truly believes. And again, there's no evidence offered that his treatments were ineffective. I believe that that's all that I have to offer you today. I appreciate your time, your willingness to look through the agency record. We ask that the agency order be vacated. And if it needs to go back for further proceedings, that's fine. We can do that. But under the facts of this case, there simply is not evidence that supports the finding regarding paragraph B13, which seems to be the foundation for all the other arguments. If you have any questions, I'll be glad to attempt to answer them.
Questions? I think we're good. Counsel, thank you both. We appreciate your time and your flexibility, and especially these arguments today. They're helpful to us in deciding the case. So that concludes this morning's session. We will take your case under advisement and get you a written decision when we can. Thank you.